Afternoon. Welcome to the site event. My name is Arne Kinnunen and I work for the Ministry of Justice in Finland. And I'm acting as a moderator of this event. You are all very welcome. The title of the workshop is Gender-Based Violence as Torture Inflicted by Non-State Actors. We will discuss the ways to promote global awareness to end non-state torture crimes against women and girls. We will hear definitions of torture by non-state actors. Examples will be given and reports of the existing laws and international regulations. Finally, the aim is to talk about the possibilities to recommend a declaration concerning this issue. My friends, this side event is hosted by government of Finland and the government of Honduras. And the alliance has been on practical preparation of this side event. I present the panelists briefly. We have a group of very honored and distinguished panelists. Firstly, Jean Sarson and Linda MacDonald will present by video on their experience on the torture inflicted by non-state actors. They have had intensive 20 years developing practice in this issue, and they have published a book, Women Unsilenced, on this issue. That will be followed by Rachel Damanju, also via video. And she's a professor emeritus at the University of Cape Town, where she taught for many years in Department of Public Law. And years 2009-2015, she held a position of UN Special Rapporteur on Violence Against Women. Her video will be followed by this presentation of Lutz Oete. Lutz is a professor of international human rights law at School of Law in Oriental and African Study at the University of London. After that, we will see a video of Manfred Novak, and he's probably most likely known by everybody. He has served in various expert functions in the United Nations framework, for example, UN Special Rapporteur on Torture. After that, we will have Julissa Villenova. She's Undersecretary of Security and Forensic Pathologist. She previously held the position of Director of the Legal Medical Services of the State Prosecutor Office. And finally, we will hear Eduardo Vettere, Executive Secretary of 3, 8, 9, and 11th UN Crime Prevention and Criminal Justice Congresses, very established and honored colleague of ours. He has been a director of the Division of Treaty Affairs of UNODC. I must say the time limit is very short. We have only 50 minutes for this workshop, and I think we should go straight to the business and start the video by Jean Sarson and Linda MacDonald. Tobias, could you please play the video?
Hello, my name is Linda MacDonald, and this is Jean Sarson with me, and together we're from Persons Against Non-State Torture. It's a campaign that Jean and I started in 1993, 29 years ago, in Truro, Nova Scotia. We started working with one woman who identified herself as Sarah, and she disclosed that she was tortured and trafficked by her parents, by like-minded others, and tortured and trafficked till she was an adult woman, actually. And from that grassroots knowledge, we started our grassroots research and spoke with thousands of women all over the world, sharing the same stories as Sarah. And we've listened to their voices and developed a grassroots science research framework about what non-state torture is. And we're happy to share it with you today. So the first slide, Jean, please. What Jean and I did is we developed our work with models to help us understand the crime and the human rights violation, and then now we can use it as a form of education. So you'll see that this is the patriarchal divide that we developed, and it's part of our grassroots science, that torture is committed by non-state actors and is the intentional infliction of severe pain and suffering. So with the patriarchal divide, what we're saying is that state torture and non-state torture are basically the same as far as the action of the perpetrators are concerned. The only difference, or the main difference, is that the perpetrators in non-state torture are families, or they're strangers, or traffickers, or pornographers, pimps in prostitution, or buyers. So if you look at the acts of non-state torture, you'll compare on the left side to the state torture. There's electric shocking, beating, caging, water tortures, suffocation tortures, sexualized tortures, forced drugging, nutritional deprivation, psychological tortures, forced nakedness, sleep deprivation, and the witnessing of the torture of others, and the powerlessness. And why we call it a patriarchal divide is because in state torture, the primary victims are men. And that's where we started looking at torture after the war and warring men. But in non-state torture, it happens to women and girls primarily in their homes, in hotels, or in huts. And they deserve the same recognition of suffering the same crime of torture. Indeed, that it is the same crime and human rights violation. So that's the patriarchal divide. Next slide, Jean, please. So we're trying to explain to you with an example of 3 women that we supported, Sarah and Lynn and Elizabeth, to give you a sense of the criminal and formal networks of the organized family systems of torturers and traffickers. With Sarah, her father, her mother, even government employees were the key organizers involved in corruption and the torture and trafficking of her as a little girl up to the age of an adult woman. And her drawing shows the torture chamber in the basement of her own home that she endured for many years as a child and even as an adult woman. And Lynn is the second one. She married a man who became her torturer, her husband and her torturer. And he, along with 3 of his male friends, they kept her captive in a windowless room for 4.5 years until she escaped. This is just one example of what Lynn endured. I'll give you an example. And also there were police involved that came and tortured her, and they were part of the criminal protection of the group of her husband and the 3 friends. So Lynn endured a group gang rape where she was raped with a knife and she started to hemorrhage. And then she was taken to what she called the pig doctor, where he supposedly fixed her up and stopped her from hemorrhaging. And of course, the pig doctor would then be part of the criminal informal network. But remember that she endured much more than this. This is just one example. And then there's Elizabeth. She's a daughter of a father, a mother, and an uncle who tortured and trafficked her for many years from the time she was little to a much older person. And she was sold at the age of 5. And there's a drawing of her showing herself being transferred from her parents to strangers where she would be tortured and trafficked. Now I'll leave it the next 2 slides for Jean.
So this is the 3rd slide, a way of explaining the non-state actor torture that, like Linda said, for 29 years, we've been supporting women. Category 1, Linda has already explained. Category 2, we call it classic non-state torture, commercial-based acts, because the perpetrators are making money off of the trafficking, the prostitution, torture, and snuff pornography victimizations, and also migrant domestic worker may be enslaved and tortured by her employer. And category 3, we call it social cultural traditions or religious-based acts, and we're list here: female genital mutilation, child marriage, acid burning, and widow burning, which we're told is declining. And this list comes from UN reports. And our final explanatory PowerPoint is about global truth-telling. It's explaining the severe pain and suffering that millions of women and girls are surviving on this planet. So we start with the World Health Organization, who tells us 1/3 of the world's women and girls over the age of 15 suffer physical and sexualized violence. But because non-state actor torture is not identified, they are invisible. But we know not only are women and girls tortured, as Linda has explained in category 1, they're also exploited, and that's category 2. And the exploitation can start as newborns, and they become part of the 1 million children who suffer sexualized exploitation and suffer non-state torture too. And sexualized exploitation of women, we also know women are tortured, and also in the domestic workers who may be enslaved, and 71% of women and girls are part of the enslavement and forced labor. And some of these women will be tortured by their employer. And prostituted women, they do our participatory research, and they talk about the non-state torture that they've suffered, category 2 again. Category 3 starts with child brides, and they may also suffer non-state torture by their so-called in-laws or others. FGM, category 3 again. And widow rituals, that's also category 3, and they may be suffered commercial based if they're forced into prostitution, acid burning, and sorcery and witch hunts. And they may be tortured, and they may also end up as a femicide. And what we're asking for state parties to do is to work collectively to create a declaration that can work as a model strategy to raise global awareness and to end non-state actor torture.
Thank you.
Thank you very much for this video, Jean Sarson and Linda McDonald. We must leave the discussion to the end of the session after all the presenters have had their time. Otherwise, I don't think we would manage. I would also let you know that in this room, besides me, we have distinguished colleagues Julissa Villanueva and Eduardo Vettere here besides me. I think we should go straight forward and have a video from Russia.
Distinguished delegates, colleagues and friends, thank you for inviting me to participate in this side event during the 31st session of the Commission on Crime Prevention and Criminal Justice. I acknowledge the hosts, the Government of Finland and Honduras, and the organizers, the Alliance of NGOs in Crime Prevention and Criminal Justice. The starting point for me at this side event is that the topic of gender-based violence as torture inflicted by non-state actors is not a new phenomenon for people who work in the field. The numerous manifestations, motivations, and non-state actors involved has been captured in submissions and reports presented to the UN human rights institutions, including treaty bodies and special procedures mechanisms. My work over the years has noted the language used by victims of gender-based violence, including referring to their experience as torture. For example, in the context of domestic violence and the inability to escape from a spouse who sleeps with a gun under his pillow. Another example is that of women and girls who experience violence in the extended family, including acid attacks and for being perceived as transgressing societal norms. Another example is the violence experienced by women in countries with pervasive problems linked to drugs and crime and gangs, where the torture manifests in horrific ways and includes physical and sexual violence, the mutilation of the body, and the placement of body parts in different locations of the city. Victims of trafficking, slavery-like practices, human rights defenders, victims of forced marriages, FGM, also describe their experience as torture. In non-conflict zones, I've heard women speak about the low-level warfare that they experience on a daily basis in their homes and communities due to gender-based violence. Unfortunately, the reality of such victims is not framed by the state as torture, but continues to be underpinned by notions of women as lesser beings whose experiences of human rights violations at the hands of non-state actors are not of the same importance as violence perpetrated in the public sphere or at the behest of the state. Globally, there is an acceptance that violence against women is a widespread and pervasive problem, and it is the foremost cause of death and disability amongst women, according to reports by the World Health Organization. However, despite such acknowledgement, the statistics indicate that response and prevention to all manifestations of violence against women is inadequate or non-existent, and impunity for such crimes is the norm. Thus, we meet today to once again raise awareness of non-state torture as experienced by women and girls, and to do so hopefully through the adoption of a declaration. The second point I'd like to raise is a recent journal article on engendering torture reinforces the reality that the Convention Against Torture and the committee's work had little interest in the early years in exploring the role that sex and gender may play regarding the practice of torture or other forms of ill treatment. By 1998, in just 25% of state reports monitoring was the issue of gender torture raised. However, we've seen improvements, and by 2020, research indicates that the committee is paying more attention to the gender dimensions of torture and other ill treatment, more especially in the context of violence against women. The adoption in 2007 of General Comment 2 reflects the shift in the monitoring work of the committee, that is away from solely a state-centric approach to gender torture. Paragraph 18 is particularly strong regarding state responsibility for acts perpetrated by non-state actors. And it states, amongst others, the state bears responsibility for consenting to or acquiescing in impermissible acts, and the failure of the state enables non-state actors to commit acts with impunity, which are impermissible under the convention. Sadly, the author of this journal article, who was a member of CAT for many years, asserts that in recent years, some new members of the CAT committee have been challenging and rejecting the inclusion of issues regularly addressed by CAT concerning women and children. These new members argue that conclusions should be gender neutral, and they question the inclusion of domestic violence and the due diligence concept, which gives rise to positive obligations. This is a retrogressive development and is a warning sign in respect of the appointment of members who do not have a gendered understanding of torture. My third point is regarding my thematic reports during my tenure as the Special Rapporteur on Violence Against Women to the Human Rights Commission and the General Assembly, where I identify some continuing challenges in attaining the goal of elimination of all manifestations of gender-based violence against women and girls. Some of these challenges include the shift in understanding of gendered responses, and also a shift to gender neutrality in laws, policies, and practices. The persistence of the public-private dichotomy and the binary approach in responses to gender-based violence. The failure of states to act with due diligence in their responses and preventative measures. The lack of transformative remedies that address root causes of gender-based violence at the individual, communal, institutional, and structural levels. The failure of states to make linkages between gender-based violence and other systems of oppression, which are a reality for women. Financial constraints and austerity measures, which result in cuts to social services spending. And the privileging of sexual violence in conflict, which we've seen in recent years, without understanding that the violence in conflict situation functions on a continuum and is exacerbated during times of conflict. And finally, the lack of specific legally binding obligations on states emanating from treaties within the international human rights systems corresponding to preventing and eliminating violence against women and girls. A fourth point is the legitimacy of violence against women as a human rights normative claim has been established through soft law developments at the UN level and through hard law developments within 3 regional human rights systems. That is the African, the European, and the Inter-American systems, which are formal human rights systems as they currently exist. As I've noted in my reports, normativity without legality is the norm within the human rights UN system in respect of violence against women. This is done through the approach of general recommendations and general comments, through concluding observations to state parties' reports, etc., by the treaty bodies. The use of general human rights principles of respect, protect, and fulfill, the principle of state responsibility to act with due diligence, and the use of non-discrimination norms are the usual interpretive tools used by monitoring bodies as they undertake their task of oversight of treaty obligations. These tools have been used to include the issue of violations by non-state actors and the principle of state responsibility for failure to protect against and prevent harm has been utilized to address accountability of states. The limitations and gaps within the older treaties has been addressed by some independent experts within the special procedures systems, and many activists have raised the issue of treaty amendments to address the normative gaps. I've raised the issue of the adoption of an optional protocol to CEDAW, or a new specific treaty on violence against women and girls, during my tenure as the mandate holder. However, there is a reluctance by treaty bodies to engage on this due to fears of loss of hard-won gains when opening up an existing treaty for change negotiations. The arguments about proliferation of treaties, duplication, fragmentation, and costs are often raised also. The hostility and threats to the treaty body system is a reality, but this should not completely shut the door to discussions about the need to reform an outdated system of human rights protections, which continues to render invisible women victims of all manifestations of gender-based violence. In conclusion, the call for a declaration by the organizers of this forum with the goal of raising international awareness on non-state torture, which is an issue of such gravity, is a sad indictment on the failure of adherence to the 1993 Vienna Declaration's articulation of women's rights are human rights and violence against women is a human rights violation. We need to do better. In 2022, to be calling for another soft law instrument, a declaration, to create awareness is a sad indictment, considering the failures of the UN system and also member states in terms of addressing the lack of accountability for non-state torture that women and girls experience. Thank you for your attention, and I'm sorry that I can't join you at the live event.
Thank you very much for this, Rashida. And as said, the full video can be found from the Alliance website, and the discussion can continue after all the presentations. Next, I will give a floor to Lutz Oette. Lutz, are you online?
Yes, I am. Can you hear me?
Yes, we can. Please.
Thank you. Thank you to the government of Finland and Honduras and the Alliance of NGOs on Crime Prevention and Criminal Justice for hosting this timely panel on gender-based torture and inviting me to speak on discriminatory torture. Debates on gender-based torture by non-state actors have largely focused on whether the definition of torture is state-centric or should have a broader scope. The notion of discriminatory torture has arguably been neglected in these debates. As my presentation will demonstrate, though, discriminatory torture provides an important lens in assessing whether gender-based violence amounts to torture. International legal approaches to gender-based violence as discriminatory torture are fragmented. The Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, is an anti-discrimination treaty in which violence against women is viewed as a form of discrimination. The Inter-American Belém do Pará Convention, the African Maputo Protocol, and the European Istanbul Convention all combine a violence against women and discrimination approach. Human rights courts, such as the European Court of Human Rights, have dealt with gender-based violence as separate but interrelated violations of the prohibition of both torture and discrimination. The European Court, however, typically does not qualify gender-based violence by non-state actors as torture. Notably, 2 judges entertained this position in a separate opinion in Volodina versus Russia 1. The Inter-American Court of Human Rights Judge Cecilia Medina Quiroga also did so famously in the Gonzalez versus Mexico Cottonfield case. Further, the European Court does commonly not directly engage with the question whether gender-based violence fulfills the purpose element of discriminatory torture. Article 1 of the Convention Against Torture squarely recognizes discriminatory torture. This is a case where severe physical or mental pain or suffering is inflicted, I quote, for any reason based on discrimination of any kind, end of quote. The Committee Against Torture briefly referred to discriminatory torture in its general comment number 2. Notably, it emphasized that the discriminatory use of mental or physical violence or abuse is an important factor in determining whether an act constitutes torture. Yet there is limited jurisprudence or practice on this element. In some cases, such as A versus Bosnia and Herzegovina, the committee explicitly held that gender-based violence constitutes discriminatory torture. The Inter-American Court of Human Rights equally did so in Lopez Soto versus Venezuela. The International Criminal Tribunals for former Yugoslavia and Rwanda have also produced an important body of jurisprudence on discriminatory torture in case of gender-based violence. This takes us to the important question of how to establish a case of discriminatory torture. The Inter-American Court of Human Rights in Lopez Soto versus Venezuela held that discriminatory purpose was demonstrated where the aggressor sought to assert a position of domination over women and assert his relationship over power and patriarchal domination over the victim. The former UN Special Rapporteur on Torture, Professor Manfred Nowak, stated in his 2008 report that the purpose element is always fulfilled if the acts can be shown to be gender-specific. This is the case if they are aimed at correcting behavior perceived as non-consonant with gender roles and stereotypes, or at asserting or perpetuating male domination over women. The African Commission on Human and People's Rights in Egyptian Initiative for Personal Rights and Inter-Rights versus Egypt identified insults and gender-specific forms of sexual violence and threats as discriminatory. In its landmark ruling in the Shalevici case, the International Tribunal for former Yugoslavia held that the purpose of discrimination must simply be part of the motivation behind the conduct and need not be the predominating or sole purpose. These interpretations provide useful criteria for establishing discriminatory violence against women. Notably, they do not require an unduly high threshold of demonstrating the specific discriminatory purpose of torture. Discrimination in the legal and institutional framework and responses to gender-based violence are important factors in determining whether states have discharged their due diligence obligation. The judgment of the Inter-American Court of Human Rights in Lopez Soto versus Venezuela is a case in point. Discrimination is therefore linked to acquiescence by the state and can thereby bring a case within the scope of Article 1 of the Convention Against Torture. The brief review shows that the discriminatory element is critical when determining severity, purpose, and acquiescence as elements of the definition of torture. It also informs the obligations of states to prevent gender-based torture by non-state actors and to investigate, prosecute, and provide adequate redress for such violations. A finding of discriminatory torture recognizes two interrelated violations. The violation of the physical and mental integrity and human dignity inherent in gender-based violence as torture on the one hand, and the violation of equality on the other. Such a finding must not be limited to gender, but include other potential characteristics such as race or age in cases of multiple or intersectional discrimination. It can therefore provide for a holistic reflection of the nature of the violation and victimization. On a final note, a focus on discriminatory torture opens space to advance the case for transformative equality and justice as a means of effective prevention of all forms of gender-based violence. Thank you.
Thank you very much, Lutz, for this in-depth analysis of the issue we are handling here. And as said, we come to the discussions and questions later on, end of this panel. Next, I would like to invite Manfred Novak to speak to us via video. Tobias, could you be so kind and put on the video?
When the United Nations Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment has been drafted and then adopted in 1984 by the United Nations General Assembly, there was still a very traditional understanding of human rights as individual claims against states. And the whole question of non-state actors was not as important as it is today. That is the main reason why Article 1 of the Convention Against Torture is defining torture as the deliberate infliction of severe pain or suffering, whether mental or physical, for a particular purpose by a state official. And that is the reason why then all the various obligations of states, and the most important one is the obligation in Article 4 to declare torture as a crime under domestic criminal law. But torture as it is defined in Article 1, so it means that states then adopted special provisions in their domestic criminal codes where they define torture as only applicable to state officials. That means in particular the police and other security forces. Now, in the meantime, and I think the Vienna World Conference on Human Rights was a very, very important step, where also then violence against women, whether it's domestic violence, trafficking, or other forms of violence by non-state actors, was clearly defined as a human rights violation. And in the aftermath of the Vienna Conference on Human Rights in 1993, the United Nations then also adopted a declaration on violence against women and appointed a special rapporteur on violence against women with a clear mandate that went far beyond state authors, that there was also starting a whole process of rethinking whether it's a good idea that torture as one of the worst human rights violations should be restricted to state actors exclusively. This was also an issue when the Rome Conference in 1998 adopted the statute for the International Criminal Court, where torture plays an important role both as a crime against humanity, but also as a war crime. And as a crime against humanity, torture is defined in the Rome Statute in very similar terms than in the Convention Against Torture, but also referring explicitly to private groups. So that means that as a crime against humanity, also non-state actors, in particular armed groups, can and should be held accountable also for torture and also being brought to justice. When I was Special Rapporteur on Torture between 2004 and 2010, it was clear for me that I actually extended the very narrow understanding of torture. Whenever, for instance, I went to an African country where female genital mutilation is a main issue, I raised this issue, and governments had no problem whatsoever to also say that falls under my mandate as special rapporteur on torture. And the same is with domestic violence, with trafficking in women and children. When I went on official mission to Moldova, I was accompanied by the then UN Special Rapporteur on violence against women, and we looked in particular into the practice of trafficking of women and girls in particular, and recommended to the government to take particular action in order to end these forms of very widespread violence. For me also, the most important criteria for the definition of torture, in addition to the ones that are mentioned both in the Convention Against Torture and the Rome Statute, is the powerlessness of the victim. And in the classical form of violence against women, whether it's domestic violence, whether it's FGM, whether it's trafficking and similar forms, is that the perpetrator has the total power over these women and girls, and they simply cannot do anything against that. So all and it's the purpose is, of course, gender-based discrimination. So I think it clearly falls under the definition of torture in this extended way, and a wording in the convention that helps to really interpret this in a very broad way is that the Convention Against Torture is also speaking in relation to state actors of acquiescence. So it's not only when a police officer is directly torturing, but also, for instance, if a police officer is watching that somebody else, a private actor, is torturing a third person. And that is exactly the situation with FGM, for instance. If there is a country with a very high rate of FGM and the government is doing nothing, then you can clearly say that the government is accountable through not having acted, so it's acquiescent to the acts of torture. So in that sense, I think that we should redefine by means of interpretation, but perhaps also by changing certain treaties, the very narrow definition of torture, because for the victim it doesn't really make a difference whether you are tortured by a state official, by a police officer, or by a private gang or an armed group, or by your partner or husband. So in that sense, it's very important that we go beyond the very traditional understanding, and also make clear that if we define torture in criminal law, that we go beyond, because states always have the right to go beyond what they are absolutely required under international law. So I am advising all governments, if they define torture as a crime in their domestic criminal codes, that they should also extend it to non-state actors. Thank you very much for your attention, and I wish you a very interesting and inspiring conference.
My friends, this didn't work out now as we planned it to do. We changed the order of presentations here and come back to Manfred Novak's video later on. Now I would like to invite Julissa Villanova to speak to us, and to remember there's a possibility for interpretation if you choose the right canal for that. Julissa, please.
Muy buenas tardes tengan todos ustedes. Es para mí un honor. ¿Me escucha? ¿Me escucha? Hola. Muy buenas tardes tengan todos ustedes. Es para mí un honor poder participar. Escucha, ¿está bien?
Yes.
Okay.
Yes, you can be heard.
Can I speak? Ok, muchas gracias, disculpen ustedes. Primero, solo agradecer a toda la sociedad civil que se ha encargado de dirigir y coordinar este evento en el marco de la prevención del delito y la justicia penal. A ustedes, señor gobernador de Finlandia, a todos los panelistas que hoy participan y por supuesto en especial a la señora Rachida Manjú, quien estuvo en algún momento en Honduras y pudo verificar algunas situaciones que hoy compartiremos. Quiero expresarles que desde el punto médico forense, soy patóloga de oficio, tal vez de antemano les diré que compartiré algunas formas de tortura clásicas que hemos encontrado en mi país y desarrollaremos rápidamente la temática sobre la violencia de género como tortura infligida por actores no estatales. Siguiente, por favor. La siguiente, señor. Evidentemente, nosotros desde el contexto de la violencia, Honduras no está en guerra. Honduras no es un país que vive en guerra, pero la violencia impera de manera global. La incidencia clara del narcotráfico ha hecho que hoy en día Honduras sea considerado un narcoestado. Y es precisamente con un gobierno nuevo, recién creado, dirigido por una mujer, cuando se ataca fuertemente esta temática. Precisamente los conflictos armados no existen. Sin embargo, vemos con frecuencia las denuncias no atendidas de mujeres tan guapas y bellas como esta, que son torturadas por sus esposos o sencillamente aparecen en los lugares diferentes del país, encontrando cuadros dantescos como estos. Siguiente. Evidentemente, nosotros vamos a compartir aquí grupos. ¿Qué grupos criminales están asociados a infringir tortura contra las mujeres? Sin duda alguno, estos grupos que no puedo dejar de mencionar se llaman las maras y pandillas. Las maras y pandillas son grupos organizados de delincuencia que definitivamente están causando y provocando mucho daño con mucho salvajismo a las mujeres. Y aunque no son agentes estatales, son capaces de provocar cualquier cantidad de daño, peor inclusive que el que pudiera provocar la mismísima policía. A veces inclusive no podemos distinguir entre una y otra. Sin embargo, el grado de salvajismo que hay alrededor de estas ejecuciones o torturas generan especial mención. La siguiente. Quiero nada más compartir estadísticamente que Honduras es un estado feminicida. Es decir, aquí el 95% de las muertes quedan impunes. Apenas el 5% se judicializan. Es decir, la impunidad en las muertes violentas de mujeres es altísima, relacionado con muchos factores. Por ejemplo, en los últimos 5 años tuvimos un total de casi llegando a las 2.000. Sin embargo, las asociadas con los grupos criminales que están reproduciendo tortura en ella son los siguientes. Vemos entonces que las muertes en las que incidimos, en las muertes provocadas por actores como maras y pandillas en los últimos años representaron 322. Si bien es cierto, no solo las maras y pandillas provocan torturas y daños, también hay otros grupos, esposos, familiares, pero para mí la forma sanguinaria, salvaje y cruel con que las maras y pandillas provocan daños, violan, raptan a las mujeres y las someten en contra de su voluntad a todo tipo de vejámenes, merece compartir con ustedes para posteriormente discutir. Vemos entonces que en primer lugar, desde el punto de vista médico forense, yo soy patóloga y he sido la que documenta la tortura en el país. Quiero expresarles que nosotros, para poder encontrar estos hallazgos, practicamos el protocolo de modelo latinoamericano de investigación de muertes violentas de mujeres. Los estados son de la que ustedes más se imaginen. Hombres que amaban a sus mujeres y las mujeres, por ejemplo, estaban en estado de gestación y aún así las sometían y las terminan ejecutando con arma blanca, machetazos. Mujeres que evidentemente sufren de tortura sistemática y que muchas veces sus denuncias no son escuchadas. Quiero expresar que en Honduras es muy frecuente, por ejemplo, que las niñas se vinculen a estos temas. Las niñas son secuestradas de entrada y son obligadas a participar dentro de estos grupos de pandillas. Vemos, por ejemplo, en una imagen que está aquí a la derecha, cómo esta joven fue capturada porque pertenecía a estos grupos delincuenciales de maras 18 o 13. Sin embargo, la joven, una vez que logró salir de los procesos de criminalización o de la cárcel, posteriormente fue encontrada francamente torturada, amarrada y atada de pies y manos, decapitada, golpeada y ejecutada. Nos da pena sentir la impotencia que a veces no hemos podido lograr la policía, por ejemplo, dar captura a estas gentes, pero sí sabemos que los modos de lesiones desde el punto de vista forense están relacionados con la manera como ejecutan las maras y pandillas en Honduras. Ven la imagen superior donde una joven, esa ahí déjenmela, esa joven que está ahí arriba era una físico-culturista, era una mujer que trabajaba en un gimnasio de San Pedro Sula. Y la chica, al no hacerle caso a estos grupos delincuenciales, fue encontrada posteriormente atada, torturada y algunas hasta decapitadas. Ya la señora Rachida Manjú nos había dicho cuándo había llegado. Evidentemente continúa el problema. Esto ya es un caso del 2017, 18, 20, en los últimos 5 años. Vemos entonces que los pandilleros las raptan, las matan e inclusive llegan hasta apedrarlas y sofocarlas. Entonces, después de raptarlas, las torturan con un gran salvajismo que nosotros creemos que es importante que podamos combatir este flagelo. Sin duda alguna, la manera sanguinaria y obligarlas a ser prostitutas o vender drogas es de las situaciones más comunes. Siguiente. Entonces yo, a propósito de un caso, este es un caso que yo quería compartir con ustedes, son muchísimos, sí, pero este es un caso muy extraño. Algunos pensaron que esta señora que ustedes ven en este recuadro era una ama de casa, quien a sus 50 años salió a comprar el café y el pan para darle desayuno a sus niños. Sin embargo, la mujer desapareció y nunca no la encontraban. ¿Dónde está la señora del café?, decían. Y si ustedes se fijan ahí, encontramos una escena que todavía la puedo recordar porque generó mucho temor en los investigadores. Vean ustedes cómo esa mujer que está allí fue víctima de un rapto, torturada y fue colocada en un escenario de un rito satánico tan tenebroso, con la cruz invertida, y ya mirarán ustedes otros hallazgos. Y decíamos, cuando discutíamos el caso, no, eso es un suicidio, decían los investigadores. Claramente ella le entregó la vida al diablo. ¿Cuál vida al diablo? Esta mujer fue secuestrada, fue prácticamente torturada de una manera dañina. La siguiente, por favor. Vemos entonces, estas son las famosas casas locas. En las casas locas, esos grupos criminales, ay, mi Dios, cualquier mujer que caiga en una casa loca es realmente insufrible. La tortura, si logra vivir, le queda sembrada en su mente, en su cuerpo. Vemos entonces, estos son los ejemplos de casas locas donde se encuentran estas jóvenes o estas señoras, en este caso en Tegucigalpa. Siguiente. Vemos entonces la señora raptada y ustedes la ven con un atuendo típico de monje y un puñal ensartado dentro de su pecho. Vemos una cruz invertida que desde luego los investigadores lo primero que decían, no queremos entrar allí porque tenemos miedo. Ahí definitivamente está el diablo. Quiero decirles que cuando ese cuerpo llegó a nuestra morgue, inclusive nuestra gente se quedó espantada del miedo, del llanto también de algunos autopsiantes, que ya teniendo ellos la capacidad de ver esto como un fenómeno normal, primero comenzaron a orar porque tenían miedo. Yo les dije, señores, ya oramos y comencemos. Comencemos porque necesitamos llegar a resolver este caso. La siguiente, por favor. Vemos entonces que nosotros seguimos el protocolo de muertes violentas de mujeres y comenzamos a buscar cada una de las lesiones, golpes, equimosis, contusiones en la boca. Lo vemos entonces, vemos cómo a esta pobre mujer le habían dibujado y le habían hecho en vida, porque algunas lesiones están débilmente, nosotros decimos vitales, pero sí fueron hechas en vida. Observamos cómo le hicieron una estrella satánica y cruces invertidas sobre sus muñecas, equimosis, y fuimos documentando con nuestro protocolo especializado las lesiones y la vitalidad de esta lesión. Estas lesiones marcaban evidentemente una tortura extrema en una mujer que había sido secuestrada. Entonces, la manera de muerte, yo le decía a mi alumno, ¿cómo tú te pones a creer que esto es un suicidio? Si tú puedes ver la gran cantidad de lesiones que tiene esta señora que ha sido raptada y que evidentemente hay un móvil. La señora iba a traer el azúcar y el café y desaparece. ¿Qué sucedió alrededor de todo esto? La violencia entonces de este tipo, por supuesto, este tipo de tortura, si estuviera asociado a grupos o funcionarios o militares, evidentemente tuviera un castigo, pero como no está asociado a esto y estos son otro tipo de actores, evidentemente las penas son menores. Siguiente. Entonces, el equipo multidisciplinario tiene que trabajar con velocidad. De lo contrario, vemos la impunidad. Les dije que el 5% apenas de los casos se resuelven, pero cuando los casos los resolvemos es sencillamente cuando tenemos una integración de todos los actores. Los investigadores vienen a las escenas, los jueces están listos para ver y analizar el contexto de la tortura y obviamente nosotros, los forenses, no tipificamos la tortura, pero al final, el hacer el equipo nos permite decir, junto con ellos, documentar esos hechos. Siguiente. Entonces, aquí yo les podría decir para terminar, que si bien es cierto, en Honduras, lo único que la ley contempla es que la tortura solo está relacionado y se castiga en los grupos militares o de funcionarios, no en otro tipo de personas, eso lo digo. No vivimos un conflicto armado, pero yo les traigo aquí esta última diapositiva solo para que la reflexionemos. ¿Y sabían ustedes que las maras y pandillas se volvieron tan poderosas en Centroamérica? Y sobre todo quiero hablar de mi país, que infiltraron a los grupos, sobre todo encargados estatales como la policía, por ejemplo. Autoridades alertas ante las infiltraciones de maras en los entes estatales. ¿Qué quiere decir? Que ahora los mareros también son policías. No todo, entonces allí podríamos pensar, entonces hay que acusarlos porque son policías disfrazados que han usurpado la identidad de los verdaderos actores y generan esta reflexión. Realmente debiéramos de castigar diferente a los grupos que deliberadamente con salvajismo provocan en nuestras mujeres estos grados de tortura, de tratos crueles, degradantes en las mujeres. Creo que este es un buen punto de discusión. Lamentablemente, disculpen las fotografías, Honduras, soy forense y los forenses exponemos los hallazgos de lo que ustedes han estado discutiendo. Gracias.
Thank you very much, Madam Villanueva. This was most interesting, and you showed us a dramatic example of non-state torture in Honduras and how big of a problem impunity and can violence is in your country. We move forward, and next we will have a distinguished colleague of mine, Eduardo Petere, please.
Good afternoon to all participants, and of course, thank you to our host, the government of Finland and Honduras, for having worked together with a number of interested NGOs for the organization of this side event. Femicide, and which 1 year later was transformed in a resolution recommended by the Commission on Crime Prevention and Criminal Justice for the adoption of the General Assembly. A further resolution 2 years later further gave additional recommendations related to gender-based violence or femicide. So all those are very important pronouncements on the part of the maximum organ of the United Nations, the General Assembly. Of course, they are in form of simply recommendations for member states to follow. We are not speaking here of a treaty which creates obligation for the state parties to implement, but still they are extremely valuable as general principles to be followed for policymakers in order to create reforms and in order to make a criminal justice system much more fair and effective. So, having worked for so many years in the United Nations Secretariat, I would like simply here to have a call for action in order to integrate more whatever has been already recommended related to femicide and gender-based violence with the developments that have taken place in the field of protection of human rights related to torture and inhuman degrading treatment or punishment. No doubt, we have heard special rapporteurs, we are aware of numerous pronouncements of the Committee on Torture, in which basically is possible to note a development according to which the concept of torture should not simply be confined to the original definition given in the paragraph 1 of the Convention on Torture. I would like further to observe that in one of his latest reports to the General Assembly, the Special Rapporteur on Torture, Mr. Nils Melzer, exactly, this is contained in document A/74/148, is a full report devoted to the relationship between torture and other cruel, inhuman, or degrading treatment of punishment to the context of domestic violence. This means basically all that was happening related to gender killing and related to femicide, which reports that not only examines the various arguments and the various connotations that this relationship can take place, but in which there are also extremely relevant recommendations for our purpose. Another document which I think is also extremely important is the most recent report of the Secretary General on sexual violence in conflicts and conflict-related situations. It was submitted last year. There is a full examination also of the effects of COVID on the pandemic, and really is not only an examination of what has been happening in all the conflict situation and in all the countries in which there are peacekeeping missions of the United Nations, but also what's happening in post-conflict situation and really the serious situation in which cases of torture and violence against women and children is perpetrated not only by state actors, but especially by non-state actors during those periods. And I think finally, in connection with this, what we have seen in this last few weeks, probably I should say also few months, happening in Ukraine war is simply a reminder to us that also those situations should be fully taken into account when considering the question of gender violence and torture-related killing. So my call for actions is simply, and this is why the original idea of the importance of the formulation of the UN declaration on this, we don't have necessarily to impose obligations to government. Those other instruments, which are soft law recommendation, can be extremely important, like it was, for example, the Declaration on the Protection for Torture and other inhuman or degrading treatment of punishment, which was adopted by the General Assembly in 1975, which was recommended by the Fifth Congress on the Prevention of Crime and the Treatment of the Offenders at the time, held in Geneva, and in 1975, and adopted after a few months by the General Assembly. Similar thing can be said in connection with the Declaration on Basic Principles of Justice for Victims of Crime and Abuse of Power, adopted again by the Seventh Congress in Milan, and a few months later by the General Assembly. The importance of these instruments are simply from the declaration. 9 years later, there was the approval on the part of the General Assembly of the Convention Against Torture, and with all the machinery related to it, through special rapporteurs, through the Committee on Torture, etc. So I think that the time has come for kind of, if I can say so, united efforts on the part of the international community. While we are here with this, with countries like Honduras and Finland, there have been other side events organized also with the full support of a number of other countries related to gender killing. So it's a question for all those countries to work together so that probably next year, at the next session of the Commission, after 10 years, we can have a much more important declaration on femicide or on gender-related killing, which can take into account these latest developments of that we have been witnessing during these last years. And it is with this conviction that I am also obliged, and I want to report here on an important statement that the Secretary General made during the last session of the Commission on the Status of Women. And here I am going to quote, "Violence against women and girls may be the world's longest, deadliest pandemic. 1 in 3 women worldwide has directly experienced violence. Every 11 minutes, a woman is killed by a partner or a family member, often in the place where she should be the safest, her own home. We cannot accept a world in which 1/2 of humanity is at risk. Let's work together to ensure that every woman and girl can live their lives free from violence with the safety, dignity, and freedom they deserve. And also, I would add, leaving no one behind. Thank you very much.
Thank you very much, Eduardo. Your message was clear. We need to start to turn this machine to that direction that we can get more soft law instruments on this issue and get a step forward in the near future. That was very important, a very clear message. Thank you so much, Eduardo. Unfortunately, we couldn't play the video of Manfred Novak, but as Anna Alves de Frate mentioned in the chat box, this can be found from the Crime Alliance's web pages. Please, it's very interesting. Please go and see that as well. Now, we already passed the time of our official time of our side event here. Apologies for that, but I still take opportunity to open a discussion for a few minutes. I see Lutz there on the screen. Would you like to start? Or are there any other inventions? There's some time for questions. Can you please raise your hand or write to the chat box if you want to take a floor for discussion?
There's
okay,
Jeanette Westbrook has a question. Her hand is visibly up.
Yes, please.
Good morning to all. I'm definitely in support of a declaration on non-state torture as a survivor of non-state torture who has submitted a report to via Special Rapporteur on Violence Against Women. My case sits in Geneva. And I would say that the pictures that were presented by Julissa in Honduras are undeniable. These are the experiences of women. I have had some of those experiences. I lived to tell. I did forward a legal case in 1992 in Kentucky, but there were no statutes on torture, but I was very clear about my torture. So in order for us to proceed with adjudication and holding these perpetrators accountable, we have to be very clear and define what it is. If we don't have laws and acknowledgement of non-state torture, we can't really go forward with a lot of these cases. And I have to tell you, there are millions of us. I'm just one who lived to tell, and there's another, there are other survivors on this call as well. And we encourage the Alliance, we encourage the United Nations to go forward with this declaration so that we are very clear exactly as to what is taking place to women and girls around the world. Thank you. Further, I would like to say, as you move forward with the declaration.
Apologies for that, but I still take opportunity to open a discussion for a few minutes. I see Lutz there on the screen. Would you like to start? Or are there any other inventions? There's some time for questions. Can you please raise your hand or write to the chat box if you want to take a floor for discussion?
There's
okay,
Jeanette Jeanette Westbrook has a question. Her hand is visibly up.
Yes, please.
Good morning to all. I'm definitely in support of a declaration on non-state torture as a survivor of non-state torture who has submitted a report to via Special Rapporteur on Violence Against Women. My case sits in Geneva. And I would say that the pictures that were presented by Julissa in Honduras are undeniable. These are the experiences of women. I have had some of those experiences. I lived to tell. I did forward a legal case in 1992 in Kentucky, but there were no statutes on torture, but I was very clear about my torture. So in order for us to proceed with adjudication and holding these perpetrators accountable, we have to be very clear and define what it is. If we don't have laws and acknowledgement of non-state torture, we can't really go forward with a lot of these cases. And I have to tell you, there are millions of us. I'm just one who lived to tell, and there's another, there are other survivors on this call as well. And we encourage the Alliance, we encourage the United Nations to go forward with this declaration so that we are very clear exactly as to what is taking place to women and girls around the world. Thank you. Further, I would like to say, as you move forward with the declaration, that you are sure to include the work of Jean Sarson and Linda McDonald, because it's right on target. It is produced in a way that the lay person, the prosecutor, judges, and attorneys can understand exactly what it is. And we can't continue to stand with just state actor torture is the only type of torture being committed, when in fact there's more torture in non-state torture being committed against women and girls worldwide. I'm asking for your help. Help the world's women and help the world's girls. Thank you.
Thank you, Jeanette, for your intervention. It was very powerful, and we will take your items into the consider, absolutely. There was a question in chat room about the timetable by Leslie Irving Wright. When will the declaration be presented, adopted? Personally, I don't think we are that far yet that we could come up with a certain timetable. We are still in the starting phase, and we start to work with that alliance and interested member state being active in this issue. So we continue to discussion. Unfortunately, cannot tell more about that now. And you know, there's another message from UK. That is thanks for the organizers of the workshop. Thank you very much for that. Are there now more intervention? I could take one more, or the ones, let's put it that way, the ones who want to take the floor, put their hand up now, and then after that we have to quit the discussion. I see Lutz Oete willing to take the floor. Lutz, please.
Thank you. It's just, I think it's prompted by what Jeanette just told us, and the intervention by Julissa also on the need to focus on torture by non-state actors. What strikes me also when I listen to the situation in Honduras, but in a lot of other countries, is that actually states are closely involved as well. So I think one of the challenges is to bring out both dimensions. You know, the focus on non-state actors and how they can be held accountable, and how one can use the criminal justice system and the legal system more broadly to prevent this kind of torture, but then also to focus on the role of the states throughout, because there are multiple state failings that then lead to basically the lack of any legal protection. And I think that is a much broader, obviously, debate to be had in each and every society, how that can be best done. But I think for the purpose of the declaration, that needs to be closely reflected. Because also from a legal perspective, that would amount to acquiescence if we read it to oblige states really to take effective measures and failing to do so, not only in individual case, but also beyond. So there is also, I think, scope for legal interpretation to bring out all these dimensions.
Thank you, Lutz, for clearing things for us. This was very helpful. Thank you very much. Now I think it's time to put an end to this side event. I would express my deep gratitude to Alliance for NGOs of making this possible, making this to happen, and Anna and Tobias for all the great organizing of this work. And most of all, I would like to thank our great panelists of really thoughtful and insightful presentations today. And unfortunately, I'm sorry, Manfred Novak video could not be played, but as said, it can be found from the Alliance webpage. And from Finland's side, there's a question from Leslie Everett. Will Finland and Honduras take the lead in creating the declaration? From Finland's side, I'm sorry, I cannot give that promise now. I have to discuss with my capital on this. I come back to this issue. And Madam Villeneuve, would Honduras be interested in this issue?
Para nosotros sería realmente un honor poder trabajar con ustedes en ese marco de ley, en ese marco de declaración. Es necesario, sobre todo cuando los delitos en Honduras más bien fueron minimizados en el Código Penal, porque hay un Código Penal de la impunidad que más bien disminuyó los castigos para los femicidios y que ahora mismo el Congreso Nacional está cambiando. Y este es un componente que nuestros legisladores no pueden tomar en cuenta.
Thank you. That was great. And Eduardo, please.
Simply to remind that the first resolution on gender killing of the Commission was, I tried to check on some of the records, but was the draft resolution that received more co-sponsorship of countries compared to any other resolution so this is why I mentioned the importance of working together with other interested countries. And no doubt, I think simply looking at those countries which were involved, both on the studies on femicide, as well as on the further follow-up and the various reports on femicide that have been done through the years. Just to mention Austria, Spain, there are quite a number which are mentioned. Of course, it cannot be work that is done only by Honduras and Finland. You need the cooperation of all the other countries. You need to have the views of the others. It requires a work that has to be done. Probably some of these elements that came out today could also start to be explored if there is going to be there are recurrent resolution on torture prepared by the third committee. So this means that already by September, etc., some elements related to torture by non-state actors could, if there is a resolution on torture by the General Assembly, could be introduced directly in the third committee for the final resolution. Or there is also the usual annual resolution on the crime prevention and criminal justice adopted every year by the General Assembly, probably also there, some of those elements could be introduced that could be further developed, looking at the formulation and the development of a consensus for a declaration.
Thank you very much, Eduardo, for this very detailed explanation. Unfortunately, we don't have more time to go to that direction anymore. We have to end this panel now. Once again, my greatest gratitude and thanks for everybody involved, and especially all of you who took your time to follow us and took part in discussions. I wish you a very pleasant afternoon and hope to see you in the near future. Thank you.